We'll hear first from Mr. Flores.
May it please the Court. The argument today for Defense Distributed and the Second Amendment Foundation will be divided between me and my co-counsel. My co-counsel, Mr. Nightingale, is going to address the venue questions, issues of severance and transfer. He's going to go second, and I'll go first to address the motion for an injunction and the jurisdictional and other procedural defects. Now, I would like very much to launch into an inquiry about the likelihood of success on the merits, but I'm not going to do that because we have briefed that 5 times now, and the briefs before this court show that this censorship regime on the merits cannot be defended, and the Attorney General does not seriously try to defend it on that ground. Instead, once again, we have a litany of procedural objections. So let me go straight to the question of jurisdiction and make an overarching point, and then go through the laundry list of objections we have. The overarching point about jurisdiction I have is this. There is no serious dispute that this court has some kind of jurisdiction. The only debate is about which kind of jurisdiction it has. Likewise, in the courts below, there's no serious dispute that one of these courts has personal jurisdiction over this case. And so the implications are twofold. First, we know that this case is going all the way to a final judgment on the merits. And by this case, I don't mean the dispute in general or that we're going to refile somewhere. I mean this exact cause of action is going to a final judgment on the merits. If the Attorney General wins every single argument that he makes, the case goes on. The second implication we have is that this court right now has complete personal jurisdiction over all of the parties and has subject matter jurisdiction. And that's why this instance lies at the heart of the court's power under Article 3 and the All Writs Act to issue an injunction.
On the All Writs Act, if I feel we're bound by Red Barn, is your core position and relief you're requesting that this you would describe under Red Barn, this is the extreme request where the relief we would grant to you is a mandamus telling the district court to request the New Jersey court to return the case?
We do make that request. If mandamus is the route, that's the mandamus we request.
Is there any other mandamus authority you could point to that would give you, you don't contend that using mandamus we can compel the district court in New Jersey to return the case, do you?
Correct, and we contend we don't need to, and here's why. I can give you the authorities and then give you the first principles. Think about first the first principles. Whenever a court transfers a case in the first instance, whether it's the district court or this circuit, they don't have jurisdiction over the receiving court. All we do is we tell the district court, take the case, walk to the jurisdictional boundary, and hand it over. All that we're asking to do is the reverse.
Ask them to send it back.
Yes.
But if Red Barn gives us the guidelines, it says that you have to be diligent. And here, unless I'm mistaken and correct any of these assumptions, you didn't ask the district court to stay it. You didn't ask the district court in New Jersey to return it. You didn't oppose consolidation in district court. At best, the filing here that we might construe as a mandamus was filed 2 months after the transfer order. What circuit would ever say that that didn't cut off mandamus jurisdiction? What authority would you point us to?
So it depends on exactly which question we're talking about. If the diligence question is when did we seek an injunction, we were certain.
No, when did you seek a mandamus to have the New Jersey court return what was electronically transferred to them on May 20th?
So our diligence there is, we don't dispute the timing that Your Honor has indicated. We took the time to file the appellant's brief and file the mandamus petition at the same time. We know of no authority that says that the 30-day time it took us to file that brief is not diligent.
Well, 30, it's closer to 2 months, isn't it?
Fair enough, Your Honor. I don't understand the Attorney General to make that diligence argument. I don't think they say that we weren't diligent because we waited 2 months to file the briefs. Their diligence argument is a different one.
What did you mean in the response on the motions to us when you said you are not asking us in any way to enjoin the stay and severance order?
So the response we're talking about is our injunction request, and we're asking for a preliminary injunction that goes all the way.
But I'm asking you, what do you mean by that sentence?
So in that motion, we weren't asking the court to issue the stay. This court has the power to do so sua sponte. The reason we didn't ask for it is because we don't have to. It's not a jurisdictional requirement. What we need to do is make sure this court has jurisdiction, and it does. And then what they're talking about, the comedy concern, the friction concern, that is not a jurisdictional requirement. We don't need to snap the case back immediately. We know as a practical matter that the court in New Jersey isn't going to do anything with that case because of the stay order. And we know formally there's no harm done to this court's.
If we do have jurisdiction, what circuit did you cite or do you know that has ever mandamused a sever transfer grant?
A sever transfer grant?
A grant of transfer. Do you know of any circuit anywhere in the country that's ever mandamus to district courts transfer grant?
No, Your Honor, we don't see any cases on either side of the question. I think the rarity is probably a point in neither side's favor. They don't have a case. We don't have a case. The best case that we have for you is the Third Circuit case in Beaubien. And Beaubien says that someone went to the Third Circuit when a case was transferred there, and someone sought relief in the Third Circuit. And Beaubien, we've given this to you in the reply brief. It's a 2004 decision. Beaubien says relief, if any, lies in the Fifth Circuit via
No, it's
mandamus.
not a jurisdictional question. Now I'm jumping. Assuming you're right, we have mandamus jurisdiction. Has any court second-guessed a district court's determination that the interests of justice favor transferring away? We have a huge body of law commended by many circuits and followed where we compel courts to transfer. I'm asking, do you know of anyone where we would say to Judge Pittman, you can't transfer it? You were wrong on that discretionary set of factors.
Not on these all fours, Your Honor. We have plenty of transfer decisions that are intra-circuit, and the same principles will apply. I don't understand my friends on the other side to disagree. There isn't a special set of rules about how to weigh the interests of justice.
Where was he indisputably wrong in saying that the interests of justice as to New Jersey's, the claims against New Jersey, should be litigated in a court where you filed, you fought to keep it, it was always pending, you never sought to dismiss it? How is he indisputably wrong in sending it to the court that you wanted to litigate it?
They didn't want to litigate.
I'm asking counsel. Could you answer that question?
I will, Your Honor. I don't want to tread over my co-counsel's time, but I can answer, I think, the diligence question and yours at the same time. We didn't want to litigate in New Jersey. We wanted to litigate in Texas. And so we started in the Western District of Texas. We sought the injunction there immediately. And it was only because the district court in Texas said, I will not issue an injunction. You must go to New Jersey. And so we went there under protest and sought our injunction there and spent 550 days litigating it. It's his position, the Attorney General's position, that we couldn't ask for injunctive relief in Texas while things were pending in the Third Circuit. We've gone everywhere that the Attorney General told us to go because that's what he thinks the rule is, and we've been denied at every step. The jurisdictional question here is clear. If appellate jurisdiction exists, the answer is easy, and mandamus is as well. All that we need is power over the district court here in Texas, and for a mandamus and the injunction, all we need is personal. Yes, sir.
I have two questions. One is, why didn't you seek a stay immediately from the district court in the Western District of Texas? And the second one is this case not like Red Barn because part of the case is still ongoing in the Western District? And could we rule that that it was wrong to sever the part that deals with the tortious interference, that is inextricably intertwined, and that part shouldn't have been severed, but let that other part go with the New Jersey statute?
Your Honor, not precisely. So the Attorney General has given you an all-up or all-down argument below. He didn't say some of the claims should be transferred. He said all or nothing.
I don't think the court can issue partial transfers.
That may be, so our position is it's an all or nothing proposition, and
Right.
we have some anchoring claims that have to stay in Texas, and so that would be a basis for a judgment in our favor.
Don't we have at least on mandamus, don't we have the right to review whether or not the tortious interference claim should have been severed?
Yes, Your Honor. And a way to effectuate that would be to tell the district court, vacate this transfer order, and if they want to move again for some sort of different transfer of some of the claims or all of the claims, they can certainly make that motion. The district court can consider it, but in this posture, it's an all or nothing. Their argument is none of the case belongs in Texas, and so if you conclude none of the case belongs in Texas, then they'll prevail, but if some of it belongs in Texas, then we go back down to Texas and they can try to redo as a partial. See that my time has expired.
Yeah, you have time for rebuttal.
Thank you.
Mr. Nightingale?
Good afternoon, Your Honors. May it please the Court. On the merits, this case is simple. It is an abuse of discretion for a district court to sever a necessary party from the case. The Attorney General is a necessary party in the case against the State Department. Therefore, it was an abuse of discretion to sever him from that case.
But there's no interlocutory, even mandamus review of a standalone severance order. You agree?
Say again?
There is no interlocutory, even mandamus review of a standalone severance order.
Of a standalone
Right.
severance order.
So I think I'm correct on that. If I'm wrong, tell me. My question then is if that is correct legally, do you have any case, as I asked your colleague, do you have any case where a circuit has mandamused a district court's discretionary Rule 21 transfer? Rolls-Royce, Volkswagen, those were all where courts refused to transfer. Do you know of anyone anywhere where we've second-guessed that, the grant of a transfer?
Your Honor, we have not found a case, particularly on point, that grants a mandamus in the case of a grant of a transfer. That does sort of bleed into Mr. Flores' line of the argument.
Speak up a bit, please.
That part of the argument was more in Mr. Flores' wheelhouse, so I'm sure he'd be happy to address that again on rebuttal.
Do you agree that the Third Circuit...
Would you let, I'm sorry, my colleague, but why don't you let the fellows get a minute or two of argument in?
I'd be happy to hear his argument, but I do have questions. Could I have some extra time?
Of course, but they haven't even gotten to start their arguments.
Well, the point he raised is one that relates to this question. The Third Circuit How Medica case, it did explore the issue of severance and when a party is an indispensable required one. If you're familiar with that analysis, is that in line with what you were just arguing to us?
Your Honor, I'm not familiar with the Third Circuit case that you referenced.
Okay, go ahead.
My line of the argument was really focused on the merits of the severance and transfer decision. And with respect to the merits, because the Attorney General was a necessary party to this case, he could not be severed. The decision to sever him was a legal error that, by definition, constitutes a clear abuse of discretion that meets even the heightened mandamus standard.
What's your best case to say he's a necessary party? It's under Rule 19. That's what you're arguing, right?
That's correct, Your Honor.
What's your best case?
So there's no case on all fours with our fact pattern here, Your Honor. There's simply no case that we've been able to find where a state official and the federal government have engaged in this overlapping regime of censorship against a plaintiff in a way that would be illustrative before this court. That said, Your Honor, I think that this fact pattern is about as clear-cut as it gets of a party claiming an interest relating to the subject matter of this litigation. In Washington 1, the New Jersey Attorney General specifically claimed an interest in the State Department's continued regulation of our client's speech. And that explicit claim of an interest meets the test under Rule 19. Now, specifically, the interest that he claimed was an interest in continued regulation of our speech to prevent people in New Jersey from obtaining access to 3D firearms and therefore potentially violating New Jersey law. That same interest that was present in Washington 1 is present here. If we prevail, then we will receive an order that says the State Department can no longer regulate these files, and it implicates the same interest that the New Jersey Attorney General claimed in the Washington 1 litigation.
Let me ask you, there is an assumption throughout your briefing that the State Department has not complied with the settlement order and that you claim that they breached it. What exactly did the State Department do that is a breach of the settlement order?
So the State Department did several actions that violated the settlement order. The most prominent actions that it took, first, it was required.
Well, I know that they were slow in changing the regulations, but now, as I understand it, there's a motion to dismiss for mootness pending in the district court, or did he already grant it?
No, Your Honor, that motion is still pending.
Maybe he ought to stay that pending the ruling of this court. Joking, but at this point in time, it's one thing to say the State Department breached from about 2018 to whatever, 2020 or so. But at this point in time, you're saying the State Department continues to breach. Because why?
So the State Department continues to breach in two ways. The most prominent way is that it still has not issued the license to our clients that would allow us to publish the information on 3D printed firearms freely to the internet.
Why do you require a license if they're no longer under the ITAR regulations?
So, Your Honor, that implicates, so there are two answers to that. The first answer is that we're not fully out of the ITAR regulations yet. There are still ITAR regulations that apply to the speech that our clients would like to publish on the internet.
Exactly what are those? Because it's not in your pleadings.
So under Category 1 of the U.S. munitions list,
Right.
The State Department still regulates such things as technical information on automatic firearms and silencers, mufflers, and sound suppressors. If you cross-reference that with our pleading and proof below, specifically ROA 2486, 2490, and 1867, you'll see our allegations and our proof showing that our clients do wish to publish information on the VZ-58 automatic weapon, as well as the AKM automatic rifle, and then various sound suppressors and sound modifiers, things of that nature.
Okay, so the settlement agreement that you entered into, did that cover future activities by Defense Distributed?
I believe it did, Your Honor. I believe the settlement.
I've got it here, I can look it up. Well, I was just trying to get a feel for exactly what's going on. So what you're contending is that the state of New Jersey, do the commerce regulations have anything to do with your position at the present time?
So the relevance of the commerce regulations at this time is that the State Department still plays a role, an oversight and an approval role in the regulations that the Commerce Department may issue. So in that sense, the State Department has another mechanism in which it could implement regulations that would target our clients.
Another finger in the pie, so to speak.
So to speak, yes.
So you were giving to the record sites, which are helpful. So the record reflects that there are CAD files that you have not put up on the internet because of the ongoing chilling.
Yes, Your Honor. These were, I believe the references that I provided to the court
Yeah.
were the requests that we made to the Directorate of Defense Trade Controls, I believe is the acronym, asking for pre-clearance to publish these files, and the State Department at that time said no.
And what about anything in the record as to New Jersey's continued threats beyond the cease and desist letter? Is there anything in the record showing that they've done anything beyond the cease and desist?
So the most recent conduct by the New Jersey Attorney General, I believe, was the threat to enforce 3L2 against our clients, which occurred in, I believe, November of 2018.
Have there been any more contacting of servers or any of that?
No, Your Honor.
Okay, well, I looked at your, at Defense Distributed's website. Is it, certain files are up on the website right now, are they not?
Yes, Your Honor. Certain files are on the website right now. I don't believe that they fall under the ITAR regime, but I also do not believe that they convey the types of information, the full extent of the information that we wish to convey. But
Is it still true, though, that in generally speaking, the State Department exempted from ITAR weapons that are less than 50 caliber or whatever it is?
Yes, Your Honor. Some of the regulations have been removed from the ITAR regime, but some of our speech is still covered, which is what makes the New Jersey Attorney General a necessary party and what makes it an abuse of discretion to sever him.
Are they still at the library?
Yes, Your Honor. I believe we still facilitate access to our files through the public library.
In Austin?
Yes.
And only at the Austin Library?
I believe that's correct, Your Honor.
And are they still sending flash drives or some other type of file in the mail? Or has that been to Texas residents?
I don't believe we've continued with that practice, but I'll need to double check on that and we can get a more clear answer for you.
So your point on severance in association with the transfer then is, since I've way overused your allotted time, your basic point would be that as long as there are files that Defense Distributed seeks to put on the internet or otherwise distributed, but is not able to do so because of continued State Department regulation, then if the State Department were suddenly to have a change of heart and allow you to do that, then there is every likelihood that New Jersey would step in again just as they did in Washington. Is that fair to say?
Yes, Your Honor, that is fair to say. So unless the court has additional questions, we'll reserve the rest of our time.
Well, we probably will, but not at the moment. Thank you. Ms. Kay or Kai?
May it please the court. This court must dismiss this appeal because the relief that Defense Distributed seeks lies outside the scope of the Fifth Circuit's jurisdiction. First, as this court has said repeatedly, there is no direct appellate jurisdiction over an order severing and transferring a case under Section 1404A. Second, this court also cannot grant mandamus relief. Because appellants fail to move for a stay, the transfer of this case to the District of New Jersey was fully effectuated on April 20th.
But the case still remains in the Western District of Texas, and why doesn't that matter?
That's because, Your Honor, under this court's precedent in O'Neill versus United States, after a case has been severed, the two remaining cases have separate jurisdictional entities. And so that's why the case against the State Department can reach final judgment independently of the proceedings that will continue in the District of New Jersey.
Let's step back a minute before all of this procedural maneuvering. New Jersey has been pursuing this claim for 4 or 5 years now. And if this court were to, if, let's say, the district court in the Western District were to tell the State Department that it had breached the settlement agreement and that the State Department must immediately comply fully with the settlement agreement, what would New Jersey do?
Absolutely nothing, Your Honor.
Oh, so you're not pursuing Cody Wilson and Defense Distributed under your criminal law anymore?
That's not what I said, Your Honor. We would do nothing to the State Department because
I didn't say that. What would you do to, you would not stop pursuing Cody Wilson and Defense Distributed. Is that accurate?
that's not accurate, Your Honor, because it depends on what Defense Distributed does in response to.
Well, you know what they will do because they've said they will publish files on the internet.
Well, I'm not so sure, Your Honor, because as of
Don't argue with me. They publish files on the internet of exactly the type that Mr. Nightingale described. Don't dither with me about what New Jersey would do. Does New Jersey have any intent to give up its desire to put Defense Distributed out of business, which is what Mr. Grewal was and Governor Murphy were saying several years ago?
So, Your Honor, to answer your question, what Defense Distributed is currently regulated by in terms of the files that was at issue in this case previously is no longer regulated by the State Department. And we have not prosecuted them. We have not done anything to them. We do intend on enforcing Section 3L2 against anyone who may violate the law.
Well, let me read to you what 3L2 says. Stripped to its essentials, facilitating the manufacture of a firearm using a three-dimensional printer. It is a crime for any person to distribute by any means, including the internet, as used in this provision. Distribute means to sell, manufacture, give, provide, lend, trade, mail, deliver, publish, circulate, disseminate, present, exhibit, display, share, advertise, offer, or make available by any other means, blah, blah, blah. And that is a crime punishable by 3 to 5 years imprisonment. Well, distributing on the internet, let's say they had a silencer that they wanted to distribute on the internet. That would violate this law, would it not?
Not if they restrict it to outside of New Jersey, which is
Has anyone been indicted under that law yet, even in New Jersey?
with respect to 3L2, I believe the answer is no, Your Honor. There are other aspects of the law.
Am I right that the Third Circuit can certify to get interpretive views, but we never have authority?
Absolutely. The New Jersey Supreme Court only allows certification from the Third Circuit.
Are you familiar with the Supreme Court's recent remand to our court in McKesson, asking us to certify a question for state court? Are you familiar with that case?
I am not, Your Honor.
Is there any aspect of this law that is constitutional?
I believe all of it is constitutional, Your Honor.
Of course you do, but publishing is is anything put on the internet speech?
I think many things on the internet are speech, Your Honor, but just because it's on the internet doesn't mean it is speech.
Well, related to
What?
that question, it is true, Judge Jones did dissent, 5 years ago, saying someone's got to answer the First Amendment question. And although I don't agree that I don't think any district court in any of the 3 circuits have ever said you've been dilatory or bad faith. In fact, I think you've prevailed in every single district court. So I don't see any tactics or intimidation. Nonetheless, does seem to me true that New Jersey would want to speed. Either this is speech, but you have a compelling interest, or it's not, it's a regulation of secondary effects. Very difficult issues. I don't see any court that's dealt with it, only scholars. So why wouldn't you, here's the question. I see full discretion to a district court to transfer here. It seems best to get it to the Third Circuit, and I think that'll resolve the First Amendment question. But it is a little difficult for you to argue for that when you did oppose the New Jersey court hearing it. So could you address that? That's the difficulty for me, that back at the beginning you said, no, it should be going forward in Texas.
Yes, Your Honor. So in the District of New Jersey, the only reason we asked for a stay is because of the first filed rule. There's no way around that, right? The District Court in New Jersey would have been proceeding with the exact same case as is filed in the Western District of Texas. I think Your Honors would, it's uncontroversial that having 2 cases proceeding at the exact same time, same parties with additional parties in New Jersey, exact same claims, would not be a good use of the District
Well, there
of New
will
Jersey.
be 2 cases proceeding if you are successful. There will be 2 cases proceeding at the same time in 2 jurisdictions that could come out with arguably very different results.
Your Honor,
One against the State Department and one against the state of New Jersey. And the consequence could be that they will issue radically different opinions on if anyone allows them ever to reach the merits.
Your Honor, no matter what happens, there will always be 2 cases because there are other plaintiffs who have filed the exact same case in the District of New Jersey, and they have stated to the Third Circuit
Well,
that they...
good for them, but that's not the case that's been pending. Well, the dispute's been litigated for ongoing 6 years now. And I don't care what happens with other cases. I'm talking about judicial efficiency in regard to a case that's been around quite some time.
Your Honor, I would submit that because that case also has the ability to reach final judgment in the Third Circuit on the exact same issues, there's no
Well,
benefit.
apropos of that, throughout your appellee's brief, you say, why are they so concerned about transferring the case to New Jersey? They can always ask the New Jersey court to retransfer. Well, suppose that happens. Suppose we deny relief and it goes to New Jersey and they say to the judge, of course it'll be the 3rd time they're seeking an efficient resolution, Judge, the same issues in this exact case are because the governor and the former attorney general both personally threatened my client. So that's all pending down in the Western District of Texas. Please retransfer. What will New Jersey say?
Well, the New Jersey court would be reviewing...
No, ma'am. I'm asking you. Will New Jersey say, oh, we agree. Procedurally, we won at the 5th Circuit. But the case is now in New Jersey, and our brief says throughout, you can seek retransfer. We agree. Will you agree?
We absolutely agree that they have the ability to seek retransfer.
Exactly. But it is close, it is frivolous, and frankly close to disingenuous that you keep suggesting, oh, well, they can always seek retransfer in New Jersey.
I think it's...
When you will oppose it every step of the way, will you not?
We will oppose retransfer.
Well, then why did you even bother to throw it out as if that were some kind of arguable solution
Well, the parties can litigate the issues, and it's our obligation to litigate the
No,
issues.
you want to litigate the issue into the next century, as best I can tell. I don't think there's any interest to try to maintain the constitutionality of this patently frivolous, insert as applied unconstitutional statute.
Your Honor, there is precedent even in the Third Circuit for parties to seek retransfer. It is absolutely not frivolous to say they can seek retransfer. We will oppose it on the merits of the retransfer.
In fact, that is what Wright and Miller and most circuits say is the way out of the May I just finish my question? That is the way out of the jurisdictional pickle, because the opposing counsel agrees we can't compel it. So the only relief we can give is a request. So it's got to go there. And there, if they grant the request, I assume you can mandamus to the Third Circuit, correct?
Absolutely right, Your Honor. And the Supreme Court has recognized that retransfer is very much an option in Hoffman versus Blasky, where that exact thing happened.
And other courts have also recognized that granting the relief they request, which is for us to request the New Jersey court to send it back, is perfectly acceptable also.
Your Honor, the option of asking for the Western District of Texas to ask the District of New Jersey to ask for it back is in dicta and Red Barn. However, the Fifth Circuit before Red Barn and after Red Barn, as far as I am aware, have never exercised that option. And the cases that Red Barn cites that alluded to that possibility, let me just share with you that case, which is in Warwick in the Second Circuit. What happened there was a transfer was effectuated, but it was effectuated against the local rules. The clerk was supposed to wait a certain number of days before transfer. Some courts have adopted that rule. However, they mistakenly sent the files early.
I was wondering about this. Is there a local rule in the Western District?
I do not believe so, Your Honor. I have looked.
So he transferred on May 20th.
April 20th, Your Honor.
April 20th. They didn't ask him to stay or reconsider. Did they not oppose the consolidation?
They did not oppose consolidation in the district.
What's the relevance of the pending motion to dismiss and the mootness suggestion, if any?
So I think the relevance there is as to the merits of the severance and transfer order. Of course, Judge Pittman could not have known that that was coming on April 20th when the regulations were still in effect. But if it is true, regardless of whether or not those claims are or are not moot, there is a lot of litigation that the parties there are embroiled in that we are not a part of. The State Department has not suggested on appeal or otherwise that they need the state of New Jersey to be a part of that.
A few questions. I'm sorry,
Go ahead.
Severance.
Yes, Your Honor.
To sever tortious interference with the settlement claim, why wasn't that error? I don't understand how that's not possibly not error.
Your Honor, there's two answers to that. The first is, again, jurisdictional. So as this court held in Imre Lieb, this court has no direct review of a standalone
That's not the
severance
question.
order.
I'm asking, was it error on the merits of that decision? That decision is extraordinarily wrong. So why isn't that, I don't understand how you can say it's not error.
Your Honor, it's not error because the tortious interference claims against the New Jersey Attorney General in an ex parte Young action, but under state tort law, is barred under sovereign immunity.
That's a different question altogether. It may be barred, and it may get dismissed under 12b-6 or some other mechanism because of that, but it couldn't have been severed because it goes along with the settlement. It marches hand in hand with the breach of the settlement.
Your Honor, I don't think that's error and not a clear abuse of error because it's not true that in every single case when you bring a breach of contract claim against party A, that you necessarily have to have a tortious interference claim against party B in that same lawsuit.
You don't split them out into
You've got a
different
claim.
lawsuits.
You've got a claim. You've got to separate the merits of the claim from the allegation of tortious interference.
Your Honor, I would submit that because those claims are not necessarily arising out of the same occurrence, there are two different occurrences, right? The settlement
is what allegedly the tortious interference caused. So they are exactly arising out of the breach of the settlement.
I would disagree, Your Honor. The tortious
They caused the breach of the settlement because they entered into their settlement in late July of 2018, and got a temporary approval from the State Department, started publishing their files, and 4 days later, New Jersey filed suit.
New Jersey and about 20 other state
Well, I
attorneys.
understand that, but only New Jersey has passed this prior restraint on speech, and only New Jersey had its two top legal officials threatening to put the president of Defense Distributed in jail.
A number of other states issued cease and desist letters to Defense Distributed.
Well, it doesn't matter who they choose to go at. They're the plaintiff. They pick, you can't. So the point is that there is a clear temporal connection between the beginning of the settlement and the direct and willful interference of New Jersey. And like Judge Elrod, I don't make a prediction about the merits of that claim, but for purposes of an allegation as to which the court should not sever the parties, that's all I'm looking at.
As to the severance, Your Honor, the reason it's not a clear abuse of discretion is because two reasons. One, those claims against the State Department on breach of contract, any of the evidence that you would need to demonstrate who caused them to breach the contract or not, you don't need New Jersey as a party. Their argument is that the court filings in the Western District of Washington caused that to happen.
But that New Jersey egged them on. That's their argument. New Jersey got together, met with them, said, don't do this, let's figure out a way around this. We can get around this and you can enter into a sweetheart judgment. That's all about whether New Jersey did that.
Your Honor, that doesn't mean that New Jersey has to be joined as a party.
Where in the record would I find their argument that they were indispensable under Rule 19? Where did they argue that to Judge Pittman?
Only the State Department argued that. They are not on appeal.
Defense Distributed has never made that argument.
Have you ever heard of a conspiracy case, which is essentially what this tortious interference boils down to, where you severed the conspirators in a civil case?
I personally have not, Your Honor, but that doesn't mean that it's a clear abuse of discretion, especially because two things. One, in Rolls-Royce, this court held that the cardinal factor to consider in a severance and transfer motion is judicial economy. And it definitely benefits judicial economy to have the case against the New Jersey Attorney General to be transferred to where it has been proceeding in an identical case.
No, the benefit of the judicial economy would have been if New Jersey, after we ruled in Rule 1 that the court had jurisdiction over New Jersey, that if New Jersey had just gone back and litigated in the Western District of Texas. But instead, New Jersey chose to litigate in the Western District of Washington until that went up to the Ninth Circuit 2 times, and then New Jersey chose to move, to get around the order of jurisdiction in this court by saying transfer us.
Your Honor, I think the key point to consider before getting into all of this is that this court has already lost jurisdiction. And I know that I am, not in a good position to tell this court that it's lost jurisdiction, but that is the holding.
What do you say about Beaubien?
Yeah, so I think their citation of Beaubien is actually a little bit, more than a little bit inapposite. So in Beaubien, what happened was, that's a case where the losing party asked the Third Circuit to review after final judgment the Texas court's transfer decision on a procedural issue. And the court ruled that is something completely consistent with the holdings of this court, which is that the right time to do that is to take a mandamus from the Texas court's decision to this court and to have stayed the case that way, not at final judgment in another court where the issues were entirely procedural.
We can take a mandamus on this under Red Barn and other authority.
I would submit that you cannot, Your Honor, because there is, by the time that this court has been, is looking at this case, the case is now within the Third Circuit, not this circuit.
We still have authority over the Western District, and we can ask the Western District to ask for it back.
Your Honor, I would submit that that is, I know that that was discussed as a possibility in Red Barn. I would submit that because there is no jurisdiction anywhere in this circuit to be in aid of jurisdiction under the All Writs Act, You can direct the Western District of Texas to do any number of things, but the Western District of Texas doesn't have a case or controversy before
It does have a case. It has the same case that's already, the initial case.
But under O'Neill, that case now has a separate jurisdictional
Are
character.
you familiar with the case I asked opposing counsel, the Third Circuit's Helmetica case?
I am, Your Honor.
Because there they talk about joint feasor. Joint tortfeasor is not sufficient to make somebody indispensable and dependent.
That's correct, Your Honor. And
Could I hear counsel's answer? Your time's almost done.
There's a difference between an indispensable party, which is not what they have claimed, and a necessary party.
Okay. Counsel, could you answer my question?
yes, as to the necessary party point, I think there's several answers to what you're saying, Your Honor. The first is the obvious one, which is that because the State Department regulations themselves that was challenged in the Western District of Washington, even if we had claim and interest, those are no longer in effect. So it is literally impossible for us to have claimed an interest in the enforcement of those regulations. Now they're talking about other regulations against automatic weapons, which is not what that lawsuit was about. Second, as we put in our brief, and actually as they agreed in the Western District of Washington in their briefs in that court, the argument for finding an absent party to be a necessary party is not an argument that can be raised by a person who has not asserted that interest, and certainly not by the plaintiff, because they're not the ones who are affected.
One of the arguments in your brief is that we didn't decide that we had jurisdiction, personal jurisdiction regarding the statute. Because although you had cited it in response to the other proceeding, we didn't cite it in the opinion. So I guess I need to ask you, are you seeking to use, is New Jersey seeking to use the statute against the library?
No, Your Honor. We have.
Is New Jersey, so it would not try to enforce it against the library?
I do not.
Against the person keeping the materials at the library?
The statute that we passed, 3L2, explicitly says distribute to a person in New Jersey.
Right, but it could get there if it's a person visiting the library. And so that's why I want to make sure that if the person from New Jersey happens to be at the UT football game and goes to the library, can they get it at the library, or has it been distributed to a New Jersey person?
If the person is seeking that out and accessing it for themselves, I do not believe that would fit under that
So that is not a violation of the statute?
I don't believe so, Your Honor. I don't know if I'm the one making that decision, but I do not believe so. I think under the statute, it's plain that you have to distribute to someone in New Jersey, and therefore that would not fit under that definition. But if I may address the personal jurisdiction point for just a second, Your Honor, I think in terms of regardless of who is right or who is wrong on whether or not Texas has personal jurisdiction as to the statutory claim, the fact is the district court correctly recognized that there will be litigation over that issue that will expend judicial resources if this case remained in Texas, and that would not exist, and that strain on judicial resources would not exist if this case were transferred to New Jersey.
Is it very much of a strain at all if we've just recently done this and we just have to add a couple new facts? I mean, aren't we in a position to
Well, Your Honor,
rule on that?
Well, Your Honor, the Western District of Texas would have to first
They could
do
rule.
fact-finding, and,
Or we could clarify what we meant in our prior decision.
Your Honor, that's certainly true, Your Honor, but I think the fact is what the Western District of Texas was tasked to do is to evaluate an order or a motion before it, and it cannot be a clear abuse of discretion for Judge Pittman to have considered judicial economy, which is what Rolls-Royce told him to do, and to evaluate which side, which courtroom it proceeds in and what strains on judicial economy there would be. That is the standard that he was supposed to rule under, and that is the standard that he adhered to. And I would submit to you that it cannot be a clear abuse of discretion for him to have followed the guidance of a concurring opinion of this court to consider that, and also just to recognize the undisputed fact that more fact-finding on personal jurisdiction, as Judge Elrod just alluded to, would have to happen before any finding of personal jurisdiction is made.
2016, whenever we ruled on this in the en banc, I guess. Am I wrong on the year?
I think you're correct, Your Honor.
The lay of the land was already, this was pretty ubiquitous already in the internet, in 2016.
No, it was downloaded 100,000 times within 1 week.
Right, and
after
so isn't
before
it-
the State Department, yeah.
This is everywhere, but it seems that there's sort of a single-minded approach to one individual. I guess I'm confused on that. Can you
Your Honor,
help me?
The state of play now is that, as Defense Distributed admitted in a court declaration on April 30th, it can and has restricted its website access to New Jersey ISPs. So that means when I'm in New Jersey, I cannot access the website. And so our statute thinks that's enough, right? That's what has been going on, and that is what the lay of the land is. And we are not reaching outside of the state of New Jersey in terms of our enforcement. But if they are distributing these files to the state of New Jersey, and now, opposing counsel, my friend, has said they wish to release files for automatic weapons, that is restricted if they wish to distribute that to
But
someone
I'm talking
within New
about
Jersey.
other people have this all over the internet.
So, Your Honor, I think we're entitled to some fact-finding on that issue, whether or not our statute has led to republishers using the same technology that Defense Distributed uses to restrict access to New Jersey ISP addresses.
Isn't the technology actually very simple? The original idea, as I understand, and correct me if I'm wrong, of the Defense Distributed was this single bullet gun, and there's so many better, no offense if that's offensive, but there are so many better, more technologically advanced options on the internet today. Many, many, many options.
Your Honor, I'm not an expert in that, but that's exactly what would be discussed in a preliminary injunction hearing before the district court.
Let me ask you a question. The premise of your so you don't have a beef with them if they're restricting the publication of files so as to prevent internet distribution to New Jersey ISPs. Well, I might be able to understand that if New Jersey had suddenly gone on a campaign against pornography, and it said, we don't want any more child pornography coming in to any New Jersey ISPs. But the premise of the argument has to be that what is on the internet is not speech. Or if speech is speech of a character that is not protected. And that's where your problem comes in, as far as I'm concerned, because they are still prevented, chilled, by the possibility of being sent to jail because of this regulation, right?
Your Honor, as to your question about the First Amendment and what is and isn't speech, I think the issue is that Defense Distributed hasn't given this court the ability to rule on that issue because they never filed for a preliminary injunction in the district court, as we understood that they would, and as they told the Western District of Texas that they would. They filed their Second Amendment complaint, but no preliminary injunction followed. And so therefore, without that satisfaction of Rule 8, this court has no record on which to determine whether the district court did or did not commit error in fact-finding. And fact-finding is necessary to reach the conclusion on the First Amendment because we, as the New Jersey Attorney General, would have to put in evidence about what compelling state interest there may be on any level of scrutiny with speech.
But you can't regulate speech, any kind of speech, just because you say you have a compelling interest.
Well, certainly some speech can be regulated.
Yeah,
with
well,
the
that's the whole point here, isn't it? And New Jersey has yet to have to argue about that. And you say, oh, yeah, take the case to New Jersey. And then you'll, then they'll be litigating in two forums again, won't they? But anyway, I repeat myself.
Your Honor, just on that last
No, I appreciate your argument. You've had at least 5 minutes extra, and I don't mean to disrespect your position or that of your state, except to say you've had more than enough time.
Thank you, Your Honor.
All right, thank you. Okay, Mr. Flores. I do have a question, Mr. Flores, about the settlement. Maybe it's not, maybe I don't. Okay.
Do you want to ask the question? I'm happy to answer.
No.
Let me proceed in order of importance. I think I have some citations for the court on matters of preservation that are critical. First is the question, did we preserve the necessary party argument? The answer is absolutely yes. This is record page 2096. This is in our brief as well. The State Department filed their response first, and the State Department said that the Attorney General is a necessary party. We filed second and incorporated their response by reference, as we have a right to do under Rule 10. The argument was made completely below. The necessary party argument is in the case. Now let me explain our position about why the Attorney General is a necessary party. It is twofold. The court is seeing both aspects of this. It is both the case that they are joint tortfeasors. They were hand in hand doing the same wrongdoing. In this case in Washington, the Attorney General was the aggressor, and the State Department was supposed to shield us from him, and they laid down. There was indeed a hand-in-hand cooperative effort to censor my clients. That's the joint misconduct, but that's not all that there is. The question is, does the Attorney General, did he sometime claim an interest in the subject of our litigation against the State Department? And he did. Our case against the State Department is, State Department has to enforce a settlement agreement and carry it out. And he claimed an interest in that by trying to stop it in Washington twice. He already claimed the interest. The bell has already been rung. And it is absurd for them to say that once they've rung the bell and claimed the interest when they like it, then when we come back and make them a necessary party, they can say, oh, we don't care anymore, you can't sue us about that. No law supports that position. I'd like to address the matter of duplication. If you take our view of the case, there will be no duplication. There is a second case pending in New Jersey. I am lead counsel in that case. If this case proceeds in Texas, the case in New Jersey is not going to go anywhere. We will proceed once and in only one court at a time. The duplication that their position portends is huge. They say if there are these two cases, they're going to have duplication of the personal jurisdiction issue. But if we split the state case from this case against New Jersey, we're going to have duplication of massive litigation. There's going to be massive litigation about how the First Amendment applies, both on a legal front and a factual front in two separate places. We're going to have to litigate what the files are, what they do, how easily they can be used, how prevalent they are on the internet. This is going to go over and over and over again in all of these jurisdictions. And so if you're trying to weigh where the duplication is, the scales aren't even close. There's been an issue about mootness and what to do about this changing State Department regulations. The cornerstone rule is that we judge the district court's decision on the basis of the record that it made at that time. So when the district court made its decision here, none of the regulatory changes we're talking about had happened. So mootness, if it ever is to be considered, is on remand. The AG could go back down and say, look, now the situation has changed. Now on these facts, maybe a transfer is warranted. But when the decision was made, it was a clear abuse of discretion already. And we've already explained why it's not moot. There are multiple levels, but that's not even an issue the court needs to touch. There's been a question about what the New Jersey censorship uniquely causes, apart from the State Department. We've outlined this in our brief, and I will articulate it as clearly as I can now. Right now, Defense Distributed is able to publish files on the internet everywhere in America except for New Jersey. There is a wall around New Jersey. You can access the website in New Jersey, but you have to log in, and it identifies that you're from New Jersey. You can't get the files in New Jersey. There's also the mailing that goes on. Defense Distributed does still mail files nationwide, not in New Jersey. So their censorship is unique. If we win the entire case against the State Department, New Jersey will be left alone, walled off as a censored place where Defense Distributed cannot speak uniquely. That is the harm that we're addressing here. There's been talk about a need for fact-finding below, and that is not the case. First of all, the Attorney General had an opportunity to make a record below. They say we didn't ask for the injunction that we're asking for now. In the Western District of Texas, we did. Here's another record citation for you, 1686. 1686 is when we were last in front of the Western District of Texas, the first time seeking an injunction. And we said, Western District of Texas, please issue a preliminary injunction, regardless of their arguments about personal jurisdiction. This is when the
Oh, you're talking about back in 2018?
Yes, Your Honor.
Okay.
And they said, District Court, don't issue an injunction because we have a personal jurisdiction fight. And we told the District Court then, you need to rule on the preliminary injunction no matter what, because either the case is going to be here in Texas or it's going to go to New Jersey, but we need a ruling on the preliminary injunction immediately, because regardless of what venue is. We've already made that argument. He already rejected that argument. Retransfer was submitted as a possible solution. Retransfer is not a solution. I have 3 responses to this. First of all, if retransfer were a solution, that would effectively overrule Volkswagen and every other case where this court says you can mandamus a transfer decision. Because in every case, you could always go to court number 2, ask for retransfer, and try for a do-over. But this court has issued mandamus against the original transfer decision, and here is why. Third Circuit precedent tells you, this is the Hayman case we've given you, that when you're litigating retransfer, you're not litigating the same issue as transfer in the first instance. Here we're litigating the actual transfer decision, the severance and the equities. If we get to New Jersey, we won't be litigating that. We'll be litigating law of the case. This is Hayman. Hayman tells you that this is not just a practical difficulty, it's a matter of law, higher bar. The Wright and Miller treatise says that practically it is harder to win these motions and that the matter of law bar is higher. So it is not an effective solution. The third thing I have to say about retransfer is that it doesn't solve for severance. If we get sent to New Jersey, maybe we can argue about the transfer aspect of this decision. But remember that it's a twofold decision. He severed and transferred. And we've never heard from the Attorney General how, if we go to New Jersey, we can ever solve for severance. Think about this. If they're right, and we have no remedy in this court right now, how do we ever solve the problem for our case against the State Department? What are we supposed to do? Mandamus the decision? That's what we're doing now. What are we supposed to do? Interlocutory appeal? That's what we're doing now. It's not going to be effective after final judgment. The court has held that in all of the cases. It leaves us with no remedy against the State Department. I don't know why the State Department isn't filing a brief here, except for the fact that we know their position. The State Department supports us. They think that New Jersey should be in this case. But if they're correct, we have no remedy whatsoever. And you haven't heard an answer to that.
I'll give you one more chance,
Sure.
since your red light is on also.
If the court has any questions, we'll be happy to receive them. Otherwise, I think we'll yield the balance of our time.
Okay. All right, thank you. We'll take the case under advisement.